Greetings, everyone, and welcome to another American Jurisprudence deep dive on public utilities. So we're going to be going into AmJur 2nd edition, public utilities, and of course we're going to have Black's Law at our side here to help us define any words that we might have difficulty with or need further clarification for our intents and purposes so that we leave no word behind. And that's going to be 9th edition we're using here. Yeah, let's zoom that in a little bit more here, maybe. Yeah. All right. Looks good. And I'll be checking out the chat. So any questions along the way, just let me know, and we'll take a little bit closer look into the details. In the meantime, let's get started. So this is a somewhat recent update, February of 2022. Let's go over the summary, the scope. This article discusses the law of public utilities generally, including their nature, creation, their regulation, their services, and the rates and charges. It also treats the rates and charges of carriers and of public service commissions generally, and specifically the regulation by the Federal Energy Regulatory Commission of water power projects and public utilities under authority of the Federal Power Act, and of natural gas companies by virtue of the Natural Gas Act. Public utilities are subject to a number of federal laws, including the Federal Power Act, under which the federal government regulates water power projects. These are our large dams, all right, and electric utilities. And the Natural Gas Act, which the federal government regulates natural gas companies. So we got our hydroelectric dams, and we have gas, where the federal government regulates these. Also discussed is the Public Utility Regulatory Policies Act. This is the one we're going to probably looking very closely at, which, among other things, transferred the authority of the Federal Power Commission to the Federal Energy Regulatory Commission. Actually, no, that's not the one I was looking for. So mostly what we're looking at here are the federal implications of that, but we're not going to be looking over most of the other things, which are mostly antitrust, public service commissions, things like that. All right, let's get into it. Okay, definition and nature. It is difficult to construct a definition of a public utility that would fit every conceivable case. Instead, the definition of a public utility is flexible. Whether any given enterprise is a public utility within the meaning of a regulatory scheme does not depend on some abstract, formulistic definition of public to be thereafter universally applied. So we're saying here that the meaning, within the meaning of the regulatory scheme, there's not an abstract or formulistic definition of public that will be universally applied. So generally, however, a public utility may be defined as a business or service engaged in regularly supplying the public with some commodity or service that is of public consequence or useful to the public. The determination of what constitutes a public utility likewise requires a flexible rule. No single factor is controlling in determining whether an entity is a public utility, although each must be weighed. Factors that have been considered in determining whether an entity is a public utility include the nature of this industry or the service provided, the type of market served by the industry, whether the public can enjoy the utility by permission only, or whether it is available to the entire public within the service area. Let's see, by permission only, whether the entity supplies its product or service or is devoted to the use of the public as a class, as opposed to only particular individuals. So we see if they're supplying a product that's devoted to the public as a class. We'll get closer into that, and that's footnote 9. Let's look at that really quick here. That applies to, Independent Energy Producers Association versus State Board of Equalization, California, of course, 2004. And we have the Water Company versus Miller County Water Authority, Missouri, 1997. That same footnote. Interesting. All right, Cook Dog. Good to see that you dropped in. You can always come back and look into this later, but appreciate you stopping by. Okay, let's get back here. So, number 10, the kind of competition or lack of competition in the market, monopolies, the entity's monopolization of or intent to monopolize its territory, the effect of non-regulation or exemption from regulation, or one or more persons engaged in the industry, the effect of non-regulation or exemption from regulation of one or more persons engaged in the industry, and the existence of regulation by government authority. So these are basically the factors that we would use in determining whether an entity is a public utility. Okay? And we need to weigh these factors. Each must be weighed in determining whether an entity is a public utility. So we can't look at any single one of these to say it's a public utility. We have to weigh each one of them. And if one's on, some of them are going to be on one side of the scale saying yes or no, it's a public utility. It fits the bill or not. And we weigh them on the scale, and whichever side has the most weight, well, that's going to get, it says right here, each must be weighted. So, observation, under some authority, the determination of whether an entity is a public utility is a mixed question of law and fact. Wow. Under other authority, however, the determination is a question of law. So under some authority, it could be law and fact. And under other authority, it's just about law. Interesting. Well, the determination is a question of law. I shouldn't say it's just about, but the determination of whether an entity is a public utility. Facts have to be admissible. So this gets even a little more complicated, and that's footnote 17. And that's Southwest Gas Corporation versus Arizona. Corporate Commonwealth, 1991. All right. Oh, that's Arizona. Okay, so let's see here. A business affected with a public interest is not necessarily a public utility or public service corporation. The fact that a business is affected with a public interest means that it may be regulated for the public good, even though no public trust is imposed upon the property, and despite the fact that the public may not have a legal right to demand or receive service. So now this is a nice, interesting one right here, huh? a business affected with a public interest, it's influenced by their public interest, it's not necessarily a public utility or a public service corporation. Okay, just because a business affected with a public interest means that it may be regulated for the public good, even though public trust is imposed, and despite the fact that the public may not have a legal right to demand or receive service. So I think this would be part of the factor of being a public utility. So just because it's affected with a public interest does not necessarily mean it's a public utility. Okay, it's affected with the public trust. It can be regulated for public good. Okay, even though the public trust isn't imposed upon the property. So that's an interesting concept here too. That's 14 and 15. And of course, you could look at constitutional law for 15, and 14 was the Pennsylvania 1976 versus WVCH Communications, the Public Utility Commission. Interesting on that one. So that's another nice observation here. The good thing about these observations is this really helps you understand all the different angles, whether you're on plaintiff defendant side, to understand the concepts that are going to be argued within the context of the subject matter of the case. So that being said, I have no legal knowledge or authority to give any kind of advice, or legal or lawful at all. This is strictly for entertainment and educational purposes, as we're just doing a deep dive into American jurisprudence. So none of this should be construed as any actionable advice to anyone in the audience, and don't try this at home. All right, let's continue here. Any questions in there, just let me know, and we're going to go through and clear up any terms or anything we're missing, and if the screen's filling up properly, yep, looks good. All right, so we're on to section 2. Definition and nature. Necessity of being available to public. Right to demand service. Let's see about this necessity now. Okay. Here. A public utility is open to the use and service of all members of the public who may require it. Thus, the principal determinative characteristic of a public utility is that of service to, or readiness to serve, an indefinite public who has a legal right to demand and receive its services or commodities. A public utility holds itself out to the public generally and may not refuse any legitimate demand for service, while a private business independently determines whom it will serve. We have a request to look up utility, so let's do that real quick here in the Black's Law Dictionary. And we'll be looking at 9th edition, which is rather current, so we should be able to find a good current definition that would apply today. And let me search here real quick. So again, we could look at a lot of different definitions, but we want to look at the actual, what they're going to define. The type of utilities for what we're reading here would be in Black's Law. Not that it would be the one applicable in every case involving public utilities, but it's going to give us a much better better view of what's going on as far as the use of it in this text. So 1714. Okay. So let's look at utility. So in generally here, we have from the 14th century, the quality of serving some function that benefits society. Meritoriousness. In patents, it means something else. We're going to skip the patent law. We're not going over that today, and we can get lost in that rabbit hole really quick. So 3, a business enterprise that performs an essential public service and that is subject to governmental regulation. We were looking at some of that earlier, right, about the governmental regulation. Okay, all right, we got line 1 in the house too. Nice, all right. So, public utility comes from 1895, and it's a company that provides necessary services to the public, such as telephone lines and service, electricity, and water. Most utilities operate as monopolies, but are subject to governmental regulation. And we have 2, a person, corporation, or other association that carries on an enterprise for the accommodation of the public, the members of which are entitled as a matter of right to use the enterprise's facility. So I know there was someone that was questioning about private wells too. That carries on an enterprise for the accommodation of the public, the members of which are entitled to, as a matter of right, to use the enterprise's facilities. So that's an interesting concept here for public utility. And I think that's it for utilities. Great. Thanks for that, Eric. That was a good deep dive into the word public utilities and utilities. Okay, let's see here. Extent or use of service. The private or public character of a utility does not depend upon the number of persons by whom it is used, but upon whether or not it is open to the use and service of all members of the public who may require it. To determine whether an entity is a public utility, the question is not the number or type of customers, but whether the utility has dedicated its property to public use. However, a single end user is not the public within the meaning of a code section defining a public utility. And that's 3S Bethlehem Steel Corporation versus Pennsylvania Public Utility Commission, 1998. And so we got some pretty current cases here. Okay, let's continue. Membership, cooperative or nonprofit organizations. In the absence of a statute clarifying the status of such entities, if a membership corporation, an association, or a cooperative group that furnishes primarily to its members various services commonly supplied by public utilities, such as electricity, gas, telephone, water, and similar services, confines its service to its own stockholders or to members of its own group. Interesting here. So, in the absence of a statute clarifying the status of such entities, if a membership corporation, so private membership association or cooperative group that furnishes primarily to its members various services commonly supplied by public utilities, such as electricity, gas, telephone, water, and similar services, confines its services to its stockholders or to members of its own group, and does not serve or hold itself out as willing to serve the public, it is not ordinarily considered a public utility. This is a PMA is what they're saying here. So if it's a private member association that manages the commodity, right, and it confines its services only to the members of the association, cooperative, or corporation, then they're not ordinarily considered a public utility. And that's footnote 1. Let's look at that. Now, this is an interesting concept here, and that's Cherry Lake. Wow, okay, cool. Florida, 1946, as to the effect of statutes clarifying the status of such organizations. Wow. So a little bit more research on that looks good. PMAs are good for a certain instance where you have people that aren't served by the government, maybe in remote areas, and they, have a private well or something of that nature, and it can be managed between that group without government regulation, is what I think this is getting at as well. Then there's larger ones such as cooperatives, right? Those associations that would make it a little bit different, I believe. But again, I have no expertise on this. I'm just kind of reading into what we're going over here. Let's continue. However, if the membership corporation, association, or cooperative group serves or is willing to serve the public in addition to its own membership, it is generally considered to be a public utility. Well, there we go. So, such entity is a public utility if the requirements for membership in a cooperative are so broad as to effectively extend membership privileges to the general public. That's footnote 3. I've seen this before too. That's Ohio Power, wow, versus Village of Vatica, Ohio, and that was 1969. 1870. Okay, so thus, the fact that the consistent practice of a cooperative is to extend service to all within its service area and to accept, without discrimination, all applications for membership and accept all applications from potential customers is an indication that it is, in fact, a public utility. Other facts that are indications of the status of the cooperative as a public utility include, so now these are the ones that would, basically these are that you are a public utility. They would prevent you from just, being exempt from regulations if you're running a cooperative or other type of organization, association, managing one of these utilities. So let's see what they are. The fact that it has been granted the power of eminent domain. Oh, wow. So if they're working the power of eminent domain, it becomes a public utility then. Or it may. There are indications of the status of the cooperative as a public utility. Okay, so if it's been granted the power of eminent domain, then it's going to be a good indication. If the fact that it is integrated into a power pool on the same basis as other competitors who are public utilities. The fact that it does not operate without a profit or return its profits to its members. So if it does not operate, boy, these double negatives. If it does not operate without a profit or return its profits to its members. So if they're keeping profits, the fact, that's a nice way to put it. Oh, Lord. The fact that it is under a contractual obligation to seek extended service to all unserved persons within the service area who desire such service and meet reasonable requirements as a condition of service. The fact that it is under a contractual obligation to seek to extend service to all unserved persons within the service area who desire such service. Wow, I'd love to read this one. Footnote 8, Dairyland Power Co-op versus Brennan in Minnesota, 1957. That's the end of that one. Wow. So that's some pretty interesting factors here. So we see how this works. First, we went over the general factors that would weigh into the entity being considered a public utility. Now we're looking at other indications of the status of, in case the entity under question is a cooperative membership association, organization, or corporation, and to see if they would be considered a public utility and have that status, even though they're a private membership type of entity. And these are the factors there. So look at all the different factors we got to consider whenever we're looking at to see, are they legitimately a public utility? So looking at any organization structure to see that, we would go through this checklist here primarily to determine these factors being weighed in determining whether it's a public utility first. And then further, if they don't fit the bill, or maybe some do, and then there's other considerations, being a private member association or cooperative, then we would also look at these factors here. And these could be indications of the status being a public utility or not. And we have some pretty well-established case law here from 46, 37, 38. So I think what we just read here speaks a lot more than just the amount of words that you see on this page. So good stuff. Let's continue. Membership, cooperative, or nonprofit organizations. Effect of statute clarifying status of such organizations. Ooh. In some jurisdictions, statutes specifically declare that a membership corporation, an association, a membership association, or cooperative group that furnishes primarily to its members various services commonly supplied by public utilities, such as electricity, gas, telephone, water, and similar services, is a public utility, or is subject to regulation by the Public Service Commission like a public utility. In other jurisdictions, however, the statutes relieve some organizations, such as cooperatives organized under the Rural Electrification Act. Ooh, we're going back far here. From certain forms of Public Service Commission regulation. Footnote 2. And sure enough, 7 U.S.C. Wow. So again, the beauty of American jurisprudence here is that we're really saying here in some jurisdictions, so warning, look at your statutes where the jurisdiction that subject matter is going to be decided is, specifically declare anything about your membership associations, okay? Because in some jurisdictions, if they're doing something like that similar services, electricity, gas, telephone, water, similar services, that means future stuff that wasn't around when this stuff was decided, it's a public utility or is subject to regulation by their commission of whatever jurisdiction you're in, just like a public utility. But in other jurisdictions, the statutes relieve some organizations, meaning these certain cooperatives that are organized under the Rural Electrification Act, now the things like in the 30s, from certain forms of Public Service Commission regulation. So, interesting thing to look up here, 7 U.S.C. If you have any of the USC handy, or if you have those volumes, that's a great study in and of itself outside of American jurisprudence. But to me, those rules and regulations are very dry. As you can see here, American jurisprudence, we're not looking at any specific written codes or rules or anything dry, but interpretations of the meaning and intent of the law through the lens mostly of common law and how it's adapted to our modern jurisprudence system, which we can see it rapidly corroding with the newer cases that we're seeing in the footnotes. When you see stuff with the older footnotes like this is more established. This is closer to the common law purposes of our original intentions, I believe, of our justice system. Let's go along. membership, cooperative, or nonprofit organizations. Effect of articles, bylaws, or statute creating organization. Ooh. So recitals in the special statute under which a corporation is created, or in the articles of organization or the bylaws of the membership corporation. If you remember, we went over the bylaws of membership corporations in the other AmJur review on this channel. Association or cooperative group that authorize it to do business as a public utility do not make it a public utility within the jurisdiction of a public service commission or subject it to regulation as a public utility, even if the company may operate in many respects as a purely cooperative group. So, regardless of what your bylaws are saying, however, the mere fact that the charter or bylaws of a membership organization or cooperative organization prohibits it from serving other than its own members or engaging in business as a public utility is not determinative of whether it is a public utility, for it is what the organization actually does that determines that question. Beautiful stuff. So, again, let's see this again. So, recitals in the special statute under which the corporation is created. That's one. Or in the articles of organization. Or in the bylaws of the membership corporation, your recitals, right? Association or cooperative group that authorize it to do business as a public utility. So that those recitals alone, whether it's in the articles of incorporation, articles of organization, or bylaws of your membership association, corporation, or cooperative group, does not authorize it, that authorize it to do business as a public utility, do not make it a public utility within the jurisdiction of the Public Service Commission, or subjected to regulation as a public utility, even if the company may operate in many respects as a purely cooperative group. So, interesting stuff here too is the cooperative group. And we look at one is Alabama Power Company versus Coleman County Electric Membership Corporation. Electric Membership Corporation. Alabama, 1937. So, yeah, you can tell this is very deep here when we read stuff purely cooperative group. The meaning goes a little bit deeper than the words alone here. However, so we go here, the interpretation, the mere fact that the charter or bylaws of a membership or cooperative organization prohibits it from serving other than its own members or engaging in business as a public utility. So even if the organization prohibits it from serving the public, anyone outside its own stockholders or members, right? Or even if it prohibits it from engaging as a business of public utility, it's not determinative whether it's a public utility. For it is, this is what I love here, it is what the organization actually does that determines that question. So, good stuff. Oh, shit. No audio? Check. Testing. We should have audio here, right? Let me just do a quick check here and make sure we're getting audio out in YouTube land. Testing. Yep, audio looks good. Okay. Just making sure, I never know. All right. Let's proceed. Now we're on section 7, the distinction between publicly and privately owned entities. Municipal utilities. Now we're getting a little bit more deep here. Publicly owned utilities are those owned by public corporations, such as municipal public utility districts and public utility districts. A public utility owned by a municipality is held in trust for the common benefit of all its citizens and is devoted to furnishing the general public of the municipality with a fixed and definite use in its property. Observation. As a utility provider, a municipal corporation is acting in its private or proprietary role and is, to a great extent, subject to the same rules of business dealings that apply to private parties. So this is interesting here. Contract law, all these things would apply to these municipal corporations. They're acting in a private or proprietary role. So the observations we get here in American jurisprudence are really just cutting to the chase here. Calling it out the way it is. So when you read this, let's read this one more time. As a utility provider, a municipal corporation, meaning your town, your municipality, if they're providing utilities, they're a utility provider, as a municipal corporation, is acting in its private or proprietary role and is, to a great extent, subject to the same rules of business dealings that apply to private parties, which means administrative court for many of the business dealings. Not all, to a great extent. They're subject to the same rules of business dealings that apply to private parties. Now, I would just take this one step further and say that it doesn't necessarily mean that the proper venue would be administrative court to seek any remedies or resolve any issues. I would say that you could bring those elements into a case. The fact that the rules of business dealings still apply, even in, an equitable context here, perhaps. All right, so, you have rights, cops have duty. You've made it. It's all right. We held it off for you. Oh, man, you're back. Oh, jeez. All right, well, I'm glad you made it here. We haven't even got to the fee part yet. We're going to be on the fee part soon. So hang tight, and we're going to be into the fees. What I just want everyone to understand is the background here of what we're getting into is that first we want to be clear about defining what a public utility is so that we can hold them accountable for the obligations that they're required to do once they're in a position of the public trust. So it's kind of our duty to hold them accountable for their duties. Unfortunately. But it beats some other ways of doing it. Okay, on the other hand, a privately owned business is a public utility if it holds itself out to provide a utility to the general public, and a public utility may be a sole proprietorship, a partnership, or a corporation. That means if one guy owns a water well and tries to sell it, he's a public utility and now is subject to government regulation and private party dealings, etc., right? So, interesting. Privately owned business seems to be no different than a municipal corporation because they're all acting in a private or proprietary role. Nevada, I think we saw something in here about Nevada Energy too, but I'm sure they'll come back up because a lot of case law is coming up at the footnotes here. So let's continue here. Sole corporation, hang on a second. We got, it's a sole proprietorship, a partnership, or a corporation. Okay. Municipal and private utilities are subject to identical public service obligations. Municipal and private utilities, identical public service obligations. That's the Plating Board of Braintree versus Department of Public Utilities, Massachusetts, 1995. A public utility is subject to an exercise of the police power of a state or its political subdivisions, whether it is stockholder owned or publicly owned. So it's subject to an exercise of the police power of a state or its political subdivisions, whether it's even a stockholder owned or publicly owned. So the police power of a state, the public utility is subject to an exercise of. So that's some ownership negates all this. No, you cannot. It says here also, maybe you weren't here for this part here, but you cannot be the sole proprietor providing a public service. Was I think what our public utility was what we read earlier. So if you're a sole proprietor and your customer is a sole proprietor, that's not going to be considered a what's it called, a public utility. And property usage, right? And that's what we need to be clear about here. The private man is private until he's engaged with the public. And we need to be clear about how do we enter that as evidence that he's engaging with the public or he's strictly dealing with the private. And what we were going over too is the private membership associations and co-ops. Depending if you extend your services outside of the stockholders or the members, then you become, in some interpretations, a public utility. That status changes. So again, I'm not trying to give any kind of advice or anything other than to give clarity to where all the why of the what we read in these codes is. Because what the American jurisprudence is based on the intent of a law and how it's been manifested into these codes and statutes and such. So we're not dwelling on codes and statutes and those. You have to research those on your own for your own state. But the general intent of why we have these laws in the first place, so that the laws in common law was supposed to be to adapt these rules or laws to meet the needs of life and not to be self-serving. And what we see here is a lot of self-serving types of entities that have creeped into this whole scheme. So let's see here. I'm not too sure on that one, but let's keep reading on, and perhaps because, that's another consideration. Again, what we're trying to do is really define whether it's a private entity that's dealing with the public or a private entity dealing with its own members, right? And then once you get into municipal corporations and you have citizens and then public, and we're getting those distinctions too. So be aware of words like public and citizen, because citizens are members of a corporation, right? And the public are not necessarily. All right, let's continue here. So a public utility is subject to an exercise of the police power of a state or its political subdivisions, whether it is stockholder owned or publicly owned. However, because the basis for the right of both governmental and private entities to provide utility services to the public is statutory, and the franchise right of each is equal, neither entity is, per se, superior or inferior to the other. So clearly we have here that governmental and private entities both have an opportunity to provide utility services to the public. At least statutorily, the franchise right of each is equal. And neither entity is per se superior or inferior to the other. And that's Central Waterworks Incorporated, Town of Century. That's Florida. Wow, District Court of Appeals, First District, 2000. So that's somewhat... let's read this one again. Because the basis for the right of both governmental and private entities to provide utility service to the public is statutory. The franchise right of each is equal, because the right is statutory. I see. Neither is inferior nor superior to the other. Excellent. Okay, let's continue. Good stuff here. Telephone service provided by hotels. We can skip over this here. 1941, 42. Yeah. 1930. Okay. That's for comic relief. All right. Utilities provided by neighboring landowners. Under some authority, the provision of water and or sewerage by a landowner to neighboring property owners as an accommodation is sufficient to impress the provider's facility with a public service and to subject the facility to regulation as a public utility. Footnote 1, that's state 86. The ground's 87. Okay, so that's North Carolina. Under other authority, however, the provision of surplus water by a property owner as an accommodation to provide to the provider's neighbors does not subject the provider to regulation as a public utility without more substantial evidence of an intent to dedicate the provider's property to a public use. To provide neighbors. Wow. So the provision of surplus water by a property owner. The provision. So they're providing extra surplus water as an accommodation to the neighbors. Does not subject them to regulation. Okay, interesting. Yeah, we're trying. We're trying. You have rights, cops have duty. All right. So, again, we have here, back to intent. So under other authority, however, the provision of surplus water by a property owner as an accommodation to provide the neighbors does not subject the provider to regulation as a public utility without more substantial evidence of an intent. Evidence, here's critical here, of an intent to dedicate the provider's property to a public use. Number 2. Wow. 1934. So that's Kentucky and Washington. Kentucky was 54 and Washington was 34. So good stuff there. So here's some cases here. We have a cooperative is not subject to regulation by the Public Service Commission as a public utility that serves the general public when it has the right to select those that become members. Okay. Bear Hollow Restoration LLC versus Public Service Commission of Utah, 2012. Ooh. All right. We didn't get into that. Didn't say that, did it? It didn't. So we don't know. That's the beauty of this too. You're not going to get always a very much definitive answer on anything here. Silent auditor, welcome. That's the other thing here is that when we talk about things like intent, we need to, now when you start charging, now you start to think, well, what's intent? Was my intent to dedicate this provider for my property for a public use, or was my intent strictly to get profit from a few select people? You get it? So it doesn't have to say whether you're making for profit or not. It's usually the intent of that profit. Is it primarily for profit? And no, it's not ambiguity. It's an intentional vagueness, because it's not here to give direct instructions. It's really here to give a general guidance and some a compass to how to navigate the various statutes and laws and codes and municipals and corporations and administrations that you're going to encounter inevitably through the legal system, and how best to make sure that the law, the intent of the law, is being used to adapt to the needs of life. And that's where jurisprudence comes in, because the legal stuff came after all this. American jurisprudence was put there to really keep that stuff in check, and common law is to keep that stuff in its place. And somehow the administrative has creeped into the civil, the criminal, and everything. So I believe, yes, disciple of the Messiah is exactly right. We have to instruct them at this point, because clearly they're not even teaching the stuff that we're all here learning right now. And I think that's an important thing, probably the best lesson of the day to know, is that we have to be the ones to instruct them. All right, let's continue. Again, the intent. We're always focused on intent when you'll see this word come up a lot, whether the actual word or implied within the context, all throughout American jurisprudence. Right, we're on to utilities provided by real estate developers or managers. There is authority to the effect that a real estate developer who supplies water to the residents of a subdivision for compensation is serving a sufficient segment of the public to impress the water system with a public service and to subject the provision of the service to regulation as a public utility. However, it has also been found that a real estate developer who provides the facilities through which a water utility supplies water to the residents of a subdivision is not subject to regulation as a public utility if there is no showing that the real estate development is engaged in the business of supplying water to the general public for compensation. So there you go. That's another interesting concept there for compensation. It's a real estate development, and they're using the supplying water in this example. Is it going to the general public for compensation? Or, this is the showing here, so it's also been found. You get this? So we got to really interpret each case individually, and we can use a comparison for these references we have here. Footnotes 1, Griffith versus New Mexico Public Service Commission. That was 1974. And Malone versus Custom Manor, 1956. And is that New York? Okay, so in the business of supplying water to the general public for compensation. Okay, let's continue. A company formed to manage a community consisting of properties owned by various individuals is engaged in the provision of public utility service, subject to regulation, even if the company furnishes utility services only to the property owners. If a company is formed to manage a community consisting of properties owned by various individuals, right, and they're providing a public service utility, subject to regulation, even if the company furnishes utility services only to the property owners. So here again is where we read before, a membership organization, if they serve it only to their members, that they weren't necessarily considered a public utility. But here in this case, if that association is a real estate development group, and what do we have it defined as here? Developers or managers, okay, then it seems here that they could be subject, even if they do have a limited membership of who they serve, right, because of the definition of what they are. So it's also been found, right? So we got to look at this from different ways. Private membership associations may or may not be considered a public utility because they're serving a particular group. Whereas this one here has a similar group a limited class, yet they're considered a public utility. So it all depends on the state, the jurisdiction you're in. And by understanding the whole context of this is why common law applies to the area you're in. The reason for territorial jurisdiction is that in a desert area, it might be different than it is in a swamp. So the laws should reflect the environment too. And that's why there's a certain amount of vagueness that's baked into this whole jurisprudence and common law. Common law is like the unwritten laws. There's no one place to find common law. Common law has been created throughout, the basic trial and error of various engagements through the courts. So let's continue here. A company formed to manage a community consisting of properties owned by various individuals engaged in a public service subject to regulation, even if the company, so that's what we got. Moreover, the provision of utility services to the purchasers of residences in a subdivision by the Property Owners Association, if the properties are for sale to the general public, and each buyer is required to become a member of the association, subjects the association to regulation as a public utility. So there it is. You're going to require them to become members of the association because they were general public. Well, you're not going to get away from it. If you're selling to the general public, even if they become your member, you're still going to be a public utility if you're pumping that water out in your development. Beautiful stuff here. And of course, we got Florida in here, and we got, what else we got here? New Jersey, New Mexico. So we got, various climates, environments, and that's where you get 56, 74, 78, 62, well-established case law. Right, we get here, regulation, put caps on everything to where, if you exceed that cap, let's get this on, see if it'll read on the screen. Let me read it out because I don't think it fits. Regulation put caps on everything to where if you exceed that cap, you must throw the overhead away or get in trouble for exceeding regulations. And that's why regulations in the wrong context. Yeah, they shouldn't. Regulations should be more as protections than limiting factors like that. Problem with without regulations is that without regulations you end up the logical conclusion of capitalism then becomes monopoly. So we have to have regulations somewhere along the line, but they shouldn't be applying to small individuals for sure, unless they can affect the public. You can't have one person creating a public hazard either. Okay, that was that there. So I think we're clear on these the questions here. Good. All right, let's continue here. So, we saw the case laws here. Yeah. So utilities provided by landlords. Some authority considers that landlords who provide utility services to their tenants are devoting their properties to a public use, and therefore are subject to regulation as public utilities. However, other authority finds that landlords who supply electricity, gas, water, or similar service to their tenants are not devoting the property involved to a public use, and therefore are not subject to regulation as public utilities. Thus, if the landlord's service is a mere incident to some other dominant service, ordinarily renting the premises, the service is not subject to utility regulation. You guys got that? It's a mere incident to some other dominant service. Now, if they're making more money from the water bill than they are from the rent, then there's a problem, or power and water, etc. The service is not subject to utility regulation. Okay, so if it's just a mere incident to some other dominant service, the service is not subject to utility regulation. So we got here monthly aging. I haven't seen that yet, but when we get to it, we will. So we have here within a private property rights regime, individuals need the ability to exclude others from, yes. Well, that's where we get into the different kinds of membership associations or cooperatives, and etc., where you can make those kinds of arrangements. Some of these holdings are based on the reasoning that the need for customer protection is not a valid basis for regulation of landlords who supply utility services to their tenants only as public utilities. And that's where it's at Arizona, 1965 and 72. Well, Pennsylvania Public Service is 65. The Arizona Corporation Commission, 72. Okay, so this is looks like an important case here. Nicholson. Cottonwood Shopping Mall, 1971, in Utah Power and Light. Okay, so these guys are probably supplying power to the tenants. These guys are suing them because they're not getting regulated. Who knows? All right. Utilities provided by landlords, specific goods and services. It has been found that a landlord is subject to regulations of public utility if it supplies its tenants with electric power, water. On the other hand, it has been found that a landlord is not subject to regulation as a public utility on the grounds that it supplies its tenants with electric power, water, gas, or pipeline. So you get different case laws, different holdings there, right? Supporting different ways. So again, this is another beauty of American jurisprudence. You're not going to get a biased look saying, oh, this is the only way to do something. You're going to look at it from both sides. Depending where you are, you're going to have to see if you're in one of these places where maybe it's not quite your favor this way, then you have to look through other ways. And that's kind of the process we do when you're building a case or defending a case or dealing with these courts in any way. Oh, heater, steam, transportation. So there's other case laws here to look at too. So here we go. Lots of good stuff. There's that Cottonwood Mall shopping center again. Florida Public Service Commission, 78. These are pretty good holdings here, 67. So well-established case law here. And these are basically giving you, for any of these incidents that you might be dealing with, if you want to say a landlord is subject to regulation, here are some cases. If it's found they're not subject to regulation, here are the cases. Same thing, electric and water. But when they're not subject to regulation, we also have case laws for gas and pipeline, heat and steam, and transportation. So property is a foundation of every right we have, including the right to be free. And property is one of our fundamental rights. Life, liberty, and property, right? So I agree. Okay. And we're on to, let's see here. Did I miss something here? No. All right, we're on to section 13 generally. Okay, in the absence of a clear and lawful limitation, a regulated public utility has all the rights granted by and the duties imposed by general law. That's Better Plastics Incorporated versus Kissimmee Utility Authority, and that's Florida, 1987. 1988, decision approved. Wow. Okay. So, in the absence of a clear and lawful limitation, a regulated public utility has all the rights granted by and the duties imposed by general law. A public utility that has received from the public authorities a franchise that provides for the accommodation of the general public, in return, owes a duty to the public, as well as to each of the individuals who makes a demand for the use of the utility's privileges and advantages. However, the directors of a public utility owe no fiduciary duty to its customers or ratepayers. Any such relationship between the utility and the ratepayers would directly contravene, right? It would go against the existing fiduciary duty that the directors owe to the stockholders of the utility. Wow. So that's an interesting concept here. Are we paying attention? So, if it's receiving from public authorities a franchise that provides for the accommodation of the general public, in return, the public utility owes a duty to the public and to each of the individuals who makes a demand. The public and the individuals who makes a demand for the use of the utility's privileges and advantages. They owe a duty. However, the directors owe no fiduciary duty to its customers or ratepayers. So, let me stand back for a second, and I want to read deeper into this. What I'm kind of getting is that depending how you prepare your standing, are you coming as the public or an individual, or are you coming as a ratepayer or a customer? Are you the public? Are you an individual? Individual is a very broad word too. It could involve the people, a person. An individual is something that can't be separated from the rest of its parts. Its members can't be separated. That's the individual, right? Public. But a customer is very specific. Ratepayer is even more specific. This all comes to your standing. If you come with a standing saying, I'm a ratepayer, I'm a customer, you owe me a duty. No, they don't. You come to the court saying, I'm the public, I'm an individual, they owe me a duty. Well, now you might have a case. All right, let's continue here. What do we got here? It's saying here that no accident that a nation conceived in liberty and dedicated to justice for all protects property rights. But that's the thing. A nation conceived in liberty and dedicated to justice for all protects property rights, of course. Yeah, Kissimmee. Kissimmee's an interesting place in Florida, for sure. More than just Disney. All right, so there we go. I get the liberty part. Of course, it's liberty. Liberty is the key. All right. So let's continue here. Public utilities have a general duty to exercise reasonable care in the management of their personal and real property, and have an obligation to manage their facilities efficiently. Moreover, they generally must bear the expense of any utility relocation that is required to accommodate a public work. 6. Entergy Gulf States versus Louisiana Public Service Commission, 1999. All right, we get a great observation. A public utility may own private property even though it is in a favorable position of limited competition. So even if it's kind of a monopoly, it can still own private property. Wow. Okay, let's continue here. A utility has the implied power to adopt reasonable and lawful regulations without unjust discrimination for the conduct of its business. A utility also has a duty to its customers to provide service subject only to reasonable rules and regulations. See, a utility has the implied power to adopt reasonable regulations without unjust discrimination for the conduct of its business. And that's 8. Petition of Vermont Welfare Rights Organization. Wow, 1974. A utility also has a duty to its customers to provide service subject only to reasonable rules and regulations. However, because the business relationship between a utility and its customers is rooted in contract, in the absence of a lien or contract, a utility may not impose an obligation of payment for utility services on someone other than one who has actually incurred the debt. Wow. This is 11. I've heard of this before. Section 46. We'll get to that later. Much later. Because we're only on number 14. Section 14, tort liability, duty of care. Public utilities do not enjoy a general tort immunity. Instead, they owe a duty of care to the general public. You guys get that? They owe a duty of care to the general public. And that's not customers, that says public. Thus, if a utility company recognizes that its conduct, under certain circumstances, creates an unreasonable risk of harm to another, it has a duty to take reasonable precautions to prevent that risk of harm from occurring. All right, practice tip. Good stuff here now, in case you have a law practice, which again, none of this should be interpreted as legal advice in any way. We're just reading through American jurisprudence as an educational expose. Don't try this at home. A utility's violation of a statute prohibiting it from performing any lawful act may establish that the utility's negligence as a matter of law. So a utility's violation of a statute prohibiting it from performing any unlawful act may establish that utility's negligence as a matter of law. Yes, it can be. Municipals and such, it says municipal corporations and such are also included. But again, this, check your local statutes and such, regarding this stuff, because again, a utility's violation of a statute. Now, if there's no statute it's violating, then this isn't going to apply. But if you find it's violating a statute, right, that prohibits it from performing any unlawful act. Sometimes there's a statute that says public utility may not perform any lawful act, or prohibited performing anything that is not lawful within the state of so and so. It may establish if they make a violation of a statute, and a statute could be as vague as prohibiting it from any unlawful act, right? Then you can establish their negligence as a matter of law, meaning they can be sued. Utility is, to some extent, responsible for initially providing for the safe and accurate transmission of its product beyond its metering devices. You get that, past the meter. However, a utility company does not have a duty to inspect or maintain fixtures or equipment that it does not own or control. The owner or consumer assumes the burden of maintaining and inspecting such fixtures and equipment. in a manner reasonably suited to meet the service to which they are to be put. And the utility company has a right to assume that these duties have been performed by the owners. Thus, a utility company is not responsible for the condition and maintenance of fixtures that it does not install, own, or control, and hence is not liable for injuries caused by their defective condition or operation. Moreover, if a public utility has warned a customer to repair an appliance for which the utility has assumed no responsibility of maintenance, and if the utility has turned off the gas to the appliance, the utility is not required to check back to ascertain whether the repair has been made, and if so, whether it has been properly made. In an action based on the wrongful termination of a utility service, a public utility is held to the standard of ordinary care. So, standard of ordinary care. And the plaintiff must prove negligence on the part of the utility. In the absence of a contractual relationship between the plaintiff and the utility, however, a public utility may not be held liable for negligent failure to supply a service. You can't sue them for what happens to your pipe, is what I was gathering out of this, if it's under your house, right? If it's past their metering device, they're responsible to some extent, but for damages, if it's their fault, but they're not responsible for maintenance. So again, the vagueness here, it's not responsible for the condition and maintenance. It does not own or install. So if you install that water line, then they're probably not, they're going to argue they're not liable for any injuries. At least that's what I gather. So we get some cases here. The duty a public utility owes to the public extends to third persons who are affected by the utility's actions or non-actions. A utility's duties extend to individuals who are strangers to the utility's contracts with its customers. Ooh. Let's see what we get here. Oh yeah, I think this is what you told me about here. You have rights, cops have duties. Two older people in town just got their water turned off. There is a new water lady, and the people think I am just protesting the fixing of pipes or some shit, and they haven't seen the public works. Oh, really? Well, we read something here earlier that this applies here. You said something about there's protesting fixing of pipes, you say here, right? And we had read earlier that those costs are the water, they can't, I don't believe they can push those costs onto their customers directly like that. Okay, yeah, yeah, all right. I got it there. You have rights, cops have duties. Oh, man. All right, let's continue on here. So we can see here, 2006, we have a gas company. Duty of the utility company is to exercise reasonable care. What state? You said Nevada, right? You have rights? I haven't seen a whole lot of Nevada cases here, but it doesn't really matter because even if these aren't, those aren't presidential cases, they're still going to be for guidance, and they could be persuasive in that manner. But no, I don't see anything here specifically for Nevada. Okay, let's continue. All right, so on generally on section 15. one thing I would consider here, well, they might have fell behind in fees in order to get shut off, but as a service, yeah, we shouldn't be getting fees for services. Otherwise, they are where, well, listen closely, because we were talking about that they have duties to the public that they can't. We can get into more detail about those specifics as we get in here. But again, the general intent of this stuff is to protect. They have a duty to the people they serve, and even goes beyond the people they serve. It's the public in general. So let's continue here. Because the state may, under the police power, regulate a business affected with a public interest. Section, that's footnote 1. Footnote 1. Okay, constitutional law. We can, I think we went over this, but we didn't make it a section 359, that's for sure. Because a state may, under police power, regulate a business affected with a public interest, and because the prime characteristic of a public utility is that of public use or service, a state may regulate and control a public utility to protect. They may do it to control, to protect the public interest and to promote the health, comfort, safety, and welfare of the people. So notice how we go through here, right? We get public interest, right? Public use, public interest again, but we're talking welfare of the people. So these little things here are important to the distinctions. They don't put these words loosely. In the exercise of its police power, the legislature has the discretion to determine not only what the interests of the public require, but also what measures are necessary for the protection of those interests. The state may thus regulate the manner in which public utility corporations construct their systems and carry on their business within the state. Ooh, a lot of state power here. Observation. Love these observations in American jurisprudence. Regulation of public utilities is a legislative rather than a judicial function. Footnote 6. That's a lot of case laws, 98, 92, 80, as to rate making as a legislative function. Section 68. So here's our case. Before any entity may operate as a public utility in New Hampshire, it must first obtain the Public Utilities Commission's PUC permission and approval. So, New Hampshire. So look at this one here. The Public Service Commission is required to give paramount consideration to the public interest in exercising its statutory powers to regulate and supervise public entities. The desires of the utility are secondary. That's in Wyoming, Idaho. It's a rate-making legislative function. So the Public Service Commission purpose of statutes regulating utilities. So look at the purpose of these things. Purpose is something you rarely see written in the laws themselves, but we got to look at the intents to see what the laws were written for, the why. The purpose of public utility laws is to protect the consuming public and to assure adequate service while, at the same time, securing for the utility a fair opportunity to generate a reasonable return. Footnote 2, that's Bloom High School versus Illinois Commerce Commission. 99. Morningstar Water Users Association versus New Mexico. 5 Pacific, okay. Yeah. Not that old. Such statutes contemplate the actual supervision of every public utility so that continuous, uniform, and satisfactory service will be rendered to the public at reasonable rates and without discrimination. The convenience and need of the public is of primary importance under a utility statute. That's footnote 3, Fountain, Illinois. Okay, so there it is, 97. Let's get our observation here. Generally, public utilities are afforded financial safeguards because of the unique position that they occupy in the marketplace. And it is the policy of the state to prevent rather than to promote competition among public utilities. Thus, the method of regulation of public utilities is based on the theory of regulated monopoly rather than competition. However, the policy favoring a regulated monopoly over destructive competition between utilities is not an absolute rule, but is applied in light of the particular facts of each case. And that's footnote 5. State Public Water Supply District Number 8, Jefferson County versus Public Service Commission. That's in Missouri, 1980. All right. So reasonable is what is in the case law. So reasonable in one case is reasonable in another. So you read these cases and you'll see what they interpreted reasonable in that subject, in that context was. So yeah, that's why they use vague terms like reasonable in there. There has to be reasoning for it, right? There has to be some facts. Usually reasoning would include some type of quantum or a measurement, a way of us to find a degree, right, of reasoning, right? There's going to be some degree of it so that we know what's reasonable, what's not. Well, we got to be able to measure what we're comparing, right? So there's going to be some quantum reasonableness, so to speak. All right, but we're getting lost in words here. Let's continue. Construction and interpretation of statutes regulating utilities. There is no presumption of an intent on the part of the legislature to interfere with a private corporation that is a public utility any further than the public interests require so. No interference will be adjudged by implication beyond the clear letter of a regulatory measure. Oof. So they can't interfere at all with the private corporation there, right? Other than what's clearly in the letter of the regulatory measure. Because a public utility statute is in derogation of the common law, it is to be construed strictly in favor of the persons sought to be subjected to its provisions. 2004. The courts will read nothing into such a statute by intendment or implication. Intendment. Sorry, guys, but I don't know what intendment means, so we're going to find out. I have a feeling it means something to do with intent, but let's find out exactly because it's fine here. Intendment. Yeah, it is, but it's okay. Let's look at it anyways in this legal context because it's always good to do. And we're going to see, it was 909. Intendment. The sense in which the law understands something, the intendment of a contract, is that the contract is legally enforceable. Also termed intendment of law. 2. A decision maker's inference about the true meaning or intention of a legal instrument. There's no need for intendment, the court reasons, when the text of the statute is clear. Formerly also spelt intendment. Common intendment is a natural or common meaning in its legal interpretation. And 3, I love this, these. As if intendment was going to have a simple definition, right? A person's expectations when interacting with others within the legal sphere. The intendment, your expectations. Our institutions and our formalized interactions with one another are accompanied by certain interlocking expectations that may be called intendments. Even though there is seldom occasion to bring these underlying expectations across the threshold of consciousness. In a very real sense, when I cast my vote in an election, my conduct is directed and conditioned by an anticipation that my ballot will be construed in favor of the candidate I actually vote for. This is true, even though the possibility that my ballot will be thrown in the way, am I allowed to say that? Or countered for the wrong man may never enter my... This is 1969, guys. So I'm not talking about the current election, YouTube. This is true, even though the possibility that my ballot will be thrown in the wastebasket or counted for the wrong man may never enter my mind, see, as an object of conscious attention. In this sense, the institution of elections may be said to contain an intendment that the votes cast will be faithfully tallied, though I might hesitate to say, except in a mood of rhetoric, that the election authorities had entered a contract with me to count my vote as I had cast it. The morality of law. So, now I have a better knowledge of the meaning of the word intendment, and it's more about expectations. And as we see here, this is it's something that we call, even though it's where it's certain interlocking expectations in our formalized interactions, but they seldom cross the threshold of consciousness. So yeah, intendment, expectation of legal enforcement, right? Legal, the way law understands something, true meaning or intention of a legal instrument. So I think it's a great word for us to know. Let's continue. The courts will read nothing into such a statute by intendment or implication. Now we know intendment means. Okay, did we miss any cases here? No. Well, 1911, 2004, and 2008 for these two here. But this one here is from 1911. Chesapeake and Potomac Telephone Company and Manning versus Manning. So there's no presumption of intent on the part. Okay, so that's ancient. Validity of the statutes regarding utilities. So, a rightful exercise of a state's police power in the supervision of public utilities does not deprive those utilities of their property without due process of law, nor deny compensation, nor impair the obligation of any contract. If the standards of public utility statute, which are reasonably precise as the subject matter permits, are applied in accordance with the requirements and purposes of the legislation in which they appear, such standards are not unconstitutional because of vagueness or a delegation of legislative power. So a statute that sets out a procedure for the regulation of utility rates affects neither a fundamental right nor a suspect classification, and hence, when it satisfies due process requirements, it's tested by a limited judicial review. The statute is valid if it is rationally related to the achievement of a legitimate governmental purpose. And that goes to 3. So, intendment. Think of this, when you cast your vote, was a great example in there is there's an intendment that it's going to be counted for the one you voted for. You know, that the law will be understood, the meaning of that instrument, right? The law will understand the meaning of the instrument in law. What was it? Let me get that wording right. The intention, the true meaning or intention of the legal instrument. That's what it is, the meaning or intention of the legal instrument. As if a legal instrument can have an intention of its own. It's given to it, right? So, yeah, it's one of those, terms of art, I would say, almost. Let's continue. Get back. All right, let's continue. So, expenses of regulation or investigation. The state may exact the reasonable cost of regulating and supervising. We're not really looking into this stuff here. Administrative costs, revenue collect. Okay, some states governing regulatory and tax-paying powers allow for both a revenue-generating fee from a franchise and a separate fee for a permit to defray administrative costs. So let's see here. To assess a charge after the fact may anticipation fixed legislator deems. So they're talking about their price fixing here. Let's get down to the cases. Stormwater utility fee that city charged landowners on an island that was within the city's boundaries, but not on the main island, bore a reasonable relationship to the benefits conferred, and therefore landowners were not entitled to a lower rate than the ratepayers on the main island, even if the stormwater discharge from the landowner's properties did not travel through the stormwater infrastructure located on the main island. The stormwater utility funded more than infrastructure, and substantial citywide stormwater anti-pollution measures benefited landowners' properties. And that's Key West, of course, Golf Club, Homeowners Association. So stormwater fee that the city charged landowners, right? The landowners were not entitled to a lower rate. So I guess that's, versus who? City of Key West. So they're probably a separate island. What is it called? The Key West Golf Club? All right, so they were going to get charged a higher rate, but they were not, or lower, okay, but on the main island, they were not going to get a lower rate. Oh, I see, yeah, because stormwater, I see, yeah. So they all have to pay, they couldn't get a lower rate because they're on their own little island. However, it has also been found that because a public utility is not the type of private enterprise that represents a social problem and properly comes under the exercise and jurisdiction of the police power of the state and requires strict regulation supervision, a license fee imposed upon public utilities cannot be justified as an imposition of the cost of regulating that type of private enterprise. Boy, government just wants to tax itself, it seems. Can't get enough. Let's see if we had anything from Nevada on here. New Mexico, keep seeing that a lot. And controlled by courts, injunctions. This should be interesting here. Courts will control public utility service and other corporations. See here. In the use of their property only so far as necessary to secure a proper discharge of the corporation's duty to individuals or to the public. So courts will control the public service commission, the public service, and other corporations in the use of their property only so far as necessary to secure a proper discharge of the corporation's duty to individuals or the public. Remember that duty to the public that they would have to have? So the courts will control these corporations only as necessary to secure proper discharge. So discharge of the corporation's duties, right? Moreover, the courts will not enjoin the construction or use of public utilities and improvements at the suit of private individuals, unless the damage is both serious in amount and irreparable in character. However, an injunction may, under proper circumstances, be available to keep a public utility within the scope of its authority and to compel its obedience to the laws. Yeah, so that's an interesting one here too. Yeah, but enjoin is in the term, the way it's used here is we could look at it this way, to prohibit. Let me pull it up here real quick. 637. Okay, so we've got enjoin. To legally prohibit or restrain by injunction, a company was enjoined from selling its stock. To prescribe, mandate, or strongly encourage. So take your pick. It's either to prescribe, mandate, or strongly encourage, or to legally prohibit or restrain by injunction. Kind of like sanction. Okay, by injunction. All right, so there you go. I think they're using it in this context, number one. I think they can make that any more confusing. All right. So a petition required a railroad company to remove certain buildings, wow, as to judicial review of public utility rates and judicial review of public service commission orders. All right. Yeah, we're getting to section here. General duty to serve. Okay. And this, we're going to leave it off after this today. The primary duty of a public utility is to serve on reasonable terms all those who desire the service that it renders. It may not choose to serve only the portion of the territory covered by its franchise that is presently profitable for it to serve. The right to provide utility services to the public carries with it a concomitant duty to promptly and efficiently provide those same services. Upon the dedication of a public utility to public use, and in return for the grant to it of a public franchise, the public utility is under a legal obligation to render adequate and reasonably efficient service impartially, without unjust discrimination, and at reasonable rates to all members of the public to whom its public use and scope of operation extend, who apply for such service and comply with the reasonable rules and regulations of the public utility. On the other hand, the obligation of the public utility to serve the public is limited by the extent of the profession or undertaking by the utility to serve the public. Very straightforward there. Public Service Commission can require a utility to provide unprofitable services to some customers, as long as the utility is allowed a reasonable opportunity to earn its authorized rate of return on its overall investment. 94, Utah. Beautiful. I like that one there. All right, and now it's a good place to leave off. And we'll continue on section 22 next time, the refusal of service because of collateral matter. Because I think we've hit the we've gotten the foundations that I wanted to get through here as far as public utilities, so we have a better understanding of what their obligations are and their duties, and where the reasonableness of what they can impose on their customers is actually a little bit different than what they can impose on the public in general and the people. That there's obligations and duties to the people that are seemingly here, what we've read so far, that go beyond what they have duties to their paying customers. So it seems that the standing when you are going as a customer, as a paying customer with a complaint, you're not going to have a very solid standing. It's best to go in there with standing as one of the people or the public or an individual rather than a customer. As we all know, it doesn't matter how radical you are as a customer, it's not going to be a benefit to you as a man or woman. So, that being said, I'd like to thank everyone for coming along for the ride on American Jurisprudence, public utilities, and we went over their nature, their creation, the regulation, and services. And next time we'll be going into a little bit more of the rate constructions and things like that. But having this foundation will allow us to now explore some of the more details and nuanced issues that we might come across with our public utilities. Yes, and you may not be a customer, but you're part of the public, they still have a duty to you as a member of the public. So that's something where, there's a lot of ways of interpreting these things that by understanding from the American jurisprudence point of view, that we can start to approach issues we might have with a more, more solid approach. Yeah, cool. In the public, not of the public. Yeah, be of the people, right? But yeah, we're in the public. And in the public interest, you'll see the wording exactly. So, yeah, that's another thing I like to point out in American jurisprudence is that we get a lot of the wording becomes very clear that you see they use words like people, person, individual, customer, and they're used very purposefully. So I think that it's a good idea for us to pay very close attention to that wording. And for that, I would like to say thank you for everyone coming along with me on this journey. It's been a long, rather long session here, but I think that there's a lot that we could all learn from what we've come across here, and especially something that applies to everyone. I think everybody uses public utilities in one way or another, and I think that it's a good idea for us to be familiar with these foundations of how they are constructed and how they're regulated and what duties they have already baked into this whole entity of a public utility. So on that, I would like to say thanks one last time, and I hope to see you guys on the next one. Make sure you like and subscribe so that you get notifications when you hit that bell. That will be going live. And again, I really appreciate the audience and the input and the feedback so that we can all go through this journey of learning together on American jurisprudence. With that, I'll say thanks and peace out. See you on the next one.